Always been viewed as vulnerable on potentially a number of legal points. So today is the fruition of what they were worried about, and also the realization of what pro-lifers hoped those places that they could find that Roe was weak and its progeny, including Casey, was weak. And that's where they've gotten today. They had always argued that they could chip away and that they would get to this day because everybody on both sides was concerned that Roe was susceptible to this.
Shannon, stand by there. And as Shannon referred there a moment ago, these decisions are handed down electronically. There was a time not too long ago, pre-COVID, Dana, where you'd see an intern or a colleague sprinting.
No, Shannon's assistant.
Yeah, sprinting from the steps of the U.S. Supreme Court to run the decision on hard copy out to our reporters, and they read it as quickly as they can. Today's a different deal, so we're allowing our analysts to take a moment, read through these briefs, read through the opinions, and try and digest that information on behalf of what the 9 justices said. 6 in favor, 3 against. Back to Andy McCarthy in a moment, but first, Brett Baer joins us by telephone. And Brett, this is a day in history that the pro-life movement has been pushing for almost 50 years. Hello.
Yeah, Bill, Dana, good morning. It's historic, no doubt about it. And politically, it's an earthquake. It really is. And just looking through the political lens, as we often do in Washington, does this have an effect, big effect, on the election coming up? You know, perhaps on some races around the edges, Democrats will try to rally the base on this issue alone. But I think the biggest message it sends is that elections have consequences. And the Supreme Court and putting those justices on the Supreme Court really changes the fabric of our country. Now, what was said already is important to remember, which is this is not outlawing abortion across the nation. This is not the end of abortion across the nation. In a state that rules or has laws that protect it, that's still available. But there are a number of states that had legislation ready to go for this very day. So it will have an impact around the country. It'll have an impact in politics. And I think it's, it's fair to say it's an historic day.
Yeah, Brett, there's no doubt about that. The political implications will be weighed in time. There are other pressures on the American people right now that may decide these midterms, including the economy, inflation, gas prices, et cetera. All that will be sussed out in the months to come. Brett, stand by one moment. I'm going to get back to Andy McCarthy here. Andy, when you think about the composition of the courts, and you think about the significance of this ruling, and you go back some 10 years to Obamacare, many people thought a decision such as Dobbs would be held to the very end of the session. It wasn't. Does that suggest anything to you at all?
Well, no, I think they're dealing here, Bill, with competing tensions. On the one hand, the fact that this got leaked 7 weeks ago does create some pressure on the court to get the decision out the door so that it neither happens nor appears to happen that the outside pressure worked on the justices. At the same time, it does ratchet up security concerns about the justices and their families. So that's another factor that pushes them in the direction of getting it out when it was ready to go. I actually thought that it would be in the last batch, and I don't even know if today will be the last batch or not. 9 would be an awful lot for them to get through in one day. But I just think that, I thought the court handled this from top to bottom in a very professional way. I hoped that they would get the decision out quickly, but once they didn't, I think they were trying to show a stiff-spine determination that they were going to do their work. They were going to do the kind of caliber work, not only that the Supreme Court characteristically does, but that is demanded by this moment. And when it was ready to go, they let it go.
Yeah. One thing that will be very interesting, I think, Dana, is the opinion that's been released. How different is it from the opinion that was leaked back
on another network, and I'm just getting this from Twitter, so I won't. They suggest that the majority opinion is virtually identical to the one that was leaked. So we have that. Jonathan, can I ask you about security for the justices and their families? Because we've had you on air to talk about that. I know that you had talked to other judges as well and their concerns about it. We know that there have been ongoing protests outside of a few of the justices' homes over the last 50 days. There's never been an arrest of any of the protesters, even though it is against the law to do so, to protest in front of their homes. The Congress has just recently passed the bill in order to get them more security. Do you know anything about what plannings there is right now to deal with the aftermath? As you can see, there's a ton of passion there on both sides, but the angry people from Jane's Revenge, it's in the name. It's in the name, Jonathan.
Well, when people are calling for a day of rage, reason will be a stranger. And that's what we're already seeing. People feel very passionately, but there's some that can take that to violent ends. So I expect they're going to be ramping up security. In terms of federal law, now that the opinion's out, it's actually more difficult to use the law because the law was designed to allow the arrest of people who are trying to influence a pending proceeding or matter with the court. This is no longer pending. So if anything, it's going to be less likely to arrest just for the act of protest. But I think that now law enforcement is going to really be acutely aware that there are people who are likely to lose reason, lose restraint, and could well become violent. And so I expect that they will ramp up that security.
Okay, Jonathan, stand by one moment. We did not know, Dana, how Chief Justice Roberts planned to vote based on the leaked memo. Well, we have his answer today. And you wonder about the composition of the court 10, 12 years ago when I mentioned Obamacare, how he sided with the liberal justices to keep that law intact. Today, he does not necessarily have the air cover of all those votes. And Justice Roberts, Andy McCarthy, I think you were talking about this the other day. Justice Roberts can now, well, he's free up to vote and pick a side in a way that he did not before. Just explain that to our audience as you see it.
Well, Bill, I think that, when Chief Justice Roberts, not only in his first among equals role as the Chief Justice, but also when he was kind of the swing justice or one of the swing justices on a 5-4 court, he was in a better position not only to deflect cases that he would prefer the court not to take because they were too hot potato type, but also even within the framework of the cases that the court took, he was able to narrow the issues that the court would resolve. In a 6-3 split rather than a 5-4 split, he's got much less control. It takes only 4 votes for the court to accept a case, but obviously you don't take a case if you're a justice who wants to take it unless you think you can get the 5 to win. So now, when there are 5 other conservative justices besides Justice Roberts, he's not in a position to sort of bargain his vote and use that as leverage to deflect cases that he'd rather not see the court take. They have much more freedom to take cases whether he wants to take them or not.
Wow, very interesting analysis there.
I just want to maybe ask Bret Baier quickly just to reflect on one thing. Think about Mitch McConnell's decision to not have a hearing for Merrick Garland, the Supreme Court nominee of Barack Obama that he wanted to put forward. I mean, that is, if you look back and you want to see a series of events that leads to today, that was a really interesting decision back then, and it's having a big impact today.
Yeah, I think you're right, Dana. That had a massive impact. The ability for President Trump to fill the seats that enable this vote to happen. And that's what I was talking about earlier about political consequences. You could do the opposite, and it hasn't adjusted the court. But when the Senate races in Georgia both flipped to Democrat in that runoff, that changed the dynamic as well. So what we see is implications of political moments. And the Merrick Garland situation, what McConnell did, he has it as a badge of courage and says it's one of the smartest things he thinks he ever did. Obviously, Democratic leaders think it's one of the worst. This is going to be fascinating to watch because there'll be another push to get rid of the filibuster, to try to get Democrats, while they have control, to have some piece of legislation that counters this ruling.
Brett, thank you for that. Stand by. I want to bring in Carrie Severino, who joins our coverage now with the Judicial Crisis Network. Carrie, it's the first time we've been able to get your reaction, just in a broad sense. What do you make of the history we're watching now?
Wow, this is truly a historic day. We have a majority of Supreme Court justices who know how to read the Constitution as it's written, but who have the courage and the bravery to say, in the face of, you can see the violent threats and the riots out there, but to say, you know what, our job is to read the Constitution. The Constitution simply does not include this right. That doesn't mean it's off the table for people who want to try to enact it through legislative processes, but they're taking the court out of this contentious issue finally. For the last 50 years, I think it has really affected and distorted our judicial process, and I'm hopeful that we can get back to judges simply continuing to read the Constitution as it's written.
Okay, with the majority opinion here, just looking at it physically, it's more than 100 pages in length, including footnotes, and I'll give you a chance to go through it. Jonathan Turley has a moment now where he's been able to read as well. Jonathan, what sticks out to you?
Well, first of all, I think it's very important to point out what's not in the opinion, because people are already taking a considerable flight from reality in terms of what the court has said. The majority says in the opinion itself that this is confined to abortion. There's already statements that critical cases like Griswold, Obergefell, on things like same-sex marriage is now at risk. We've heard those suggestions in the past. The court directly deals with that and actually sort of swats back at the dissent for suggesting that, and says that we have stated unequivocally that nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion. And then goes on to say, we have also explained why that is so. Rights regarding contraception and same-sex relationships are inherently different from the right to abortion. And so the court puts that very plainly, that people who are suggesting that this is extending beyond this field are simply ignoring what it has said and is saying in this opinion.
Wow.
And that's important then, Jonathan, right? I mean, that's not a small nuance.
No, and this has been a sort of a talking point for the last few weeks, ever since the opinion was released. Now, many of us have pushed back on that and said there's no reason why that would be true. But here you have the court going out of its way to say enough of that. That is, this is dealing with the right to abortion. Those other rights are based on other arguments, including other rights in the Constitution, depending on which area we're talking about. But there's an effort to create a parade of horribles beyond the decision itself. Now, look, there's legitimate reasons why many people are upset about the loss of Roe and Casey. The other thing to keep in mind, by the way, we talk about overturning Roe and Casey. Casey was effectively dead. Roe was effectively dead. Casey gutted Roe and replaced it with an entirely new approach. So the court has never been on terra firma when it comes to the logic behind this right. It changed from Roe to Casey, and then later the court had a series of highly divided opinions on things like late abortion procedures and other issues. Here the court is just saying, look, we got it wrong at the beginning. It recognizes that stare decisis is about preserving precedent, but it says that doesn't mean that you can't overturn precedent. Brown v. Board of Education overturned Plessy. There are other cases that we decided are simply wrong, and that's what they're saying today.
Jonathan, thank you for that. Stand by again as we get more reaction from our excellent panel, legal analysis, and we'll get some members of Congress on here in a moment or calling in by telephone, so stand by for that, Dana.
Carrie Severino, can I ask you about what happens next in the state legislatures? Because it is not correct that now there's, for example, a lot of the reaction initially is along the lines of the court just overturned a constitutional right to abortion. Somebody like you will point out that there was no constitutional right to an abortion in the Constitution, that was contrived, and now we are back to where it should have been, which is the debates in the states. And so who has the ability to organize really well in the states in order to have their position win over the next couple of years?
Well, look, it's going to look very different across the country. You're going to have different, much as we do now, but I think just then with a broader range of legislative options, you're going to see California and New York. No change is going to happen. I think if anything, you're seeing them trying to expand abortion in those states. In somewhere like Georgia or Texas, you're going to see more protective laws of fetal life, and it's going to span the whole range. You've got a lot of states that maybe had pre-Roe laws on the books, and those laws then, because Roe is clearly and explicitly, I love the court. The court didn't try to beat around the bush. They just said explicitly what they're doing. That is very admirable. It's very clear. Okay, those laws would come back into effect. Or some states have passed laws in the intervening years that said if Roe is ever overturned, then this is what we want our abortion policy to be. So a lot of states already have taken steps, and again, in varying different directions. Not all, completely pro-life answers to that. It could be a wide range. And then you'll have states that have their constitutions that might speak to it, or in some cases, there's going to be an interesting question of state courts where their constitution doesn't speak to it, but you have a state court that effectively does what the Supreme Court did in Roe. We saw that in Kansas recently, where they kind of brought their own right to abortion into the Kansas Constitution, despite the fact that there isn't language to that effect. So some of these fights will have to be then also brought to the state court level to make sure that state courts are following their state constitutions. And again, that could be a range. That could be constitutions that say there's a right to abortion and others that don't, but you need judges who are going to follow what the Constitution says and not what their own policy views
Just
are.
a couple things to add to that, Carrie. Reading this, 13 states, mainly in the South and Midwest, have laws on the books that ban abortion in the event that Roe is overturned, which indeed happened 40 minutes ago. Another 6 states have near total bans on prohibitions after 6 weeks of pregnancy. And on it goes, and people all across the country are looking at what their own state laws are, and also what laws may be backed up and may be coming to their own state legislatures at a point very soon. Back to the reaction, however, House Speaker Nancy Pelosi just weighed in. She calls this decision cruel. She condemns the ruling, and she says women's rights are on the ballot come November. Carrie, stand by. I want to get more reaction. Guy Benson was with us about an hour ago. Guy, we were talking about this before the decision came down. Your reaction off the top now.
Well, obviously, this is a day that is historic. Many pro-life Americans have been waiting for this moment, wondering if we would ever see it, and now we have. It is a thunderclap in jurisprudence. There's no beating around the bush on that. And what strikes me about the reaction that we're seeing pouring in is that we sort of did a dress rehearsal on this a number of weeks ago when the leaked opinion came out. And essentially, what we saw those weeks ago is exactly what we're seeing with the actual decision itself. A number of people on this broadcast have pointed out that just because Roe versus Wade is being overturned in this case in Dobbs, that does not make abortion illegal across the entire country. We will see a patchwork of abortion laws from state to state, some very permissive, I would say inhumanely so, already on the books, some much more restrictive, if not close to totally restrictive. These will be decisions now made by elected representatives on behalf of people who have elected them, people who have put them and given them power. And I think that that's the key point here. There have been even progressive constitutional experts, even the late Justice Ginsburg has been critical of Roe versus Wade, the way it was reasoned. A lot of people thought it was wrongly decided, or at least they came at it the wrong way back in 1973. And so there's the constitutional question on this, which, again, many conservatives have been arguing forever, for decades, that it was wrongly decided. There's the moral, ethical, scientific element of any abortion debate, which is going to be very emotional and very divisive. And then there's the political fallout, the political outcome that we've been sort of grappling with here since the leak at the Supreme Court. And we're getting a hint or two along the way of what it will look like and what it might not actually look like vis-a-vis the upcoming elections. But now the actual moment has arrived. It's not hypothetical. It's not theoretical. It's here. Roe is gone, and history has been made.
Guy, thank you. Stand by, along with the rest of our team. Dana, the former President Barack Obama, now tweeting out the decision's tantamount to an attack on freedoms for millions of Americans. The court's conservative majority overturning it. The decision expected to lead to abortion bans in roughly half the states, and on it goes.
Well,
from the former president.
It's interesting, and Andy McCarthy, maybe weigh in here. You know, everybody looks at this and might have a different opinion, but it's interesting to me when lawyers look at something and have such radically different opinions on that. And Barack Obama is a lawyer. He was the constitutional law officer of our land for 4 years, or 8 years, excuse me. And that's just really interesting to me. And I would get your take on that, and also about Mississippi had a different approach here. And you had the Attorney General there in Mississippi who calmly executed the case in front of the court and is victorious today, and we should talk about her a little bit.
Yeah, I'd say on Obama, this is kind of a microcosm, Dana, of the whole problem here, which is that Roe was never really law in the first place. Roe was always politics, and it's become a political cause. Indeed, the people who try to argue the pro-Roe side of these cases basically argued stare decisis, the principle that we're supposed to uphold precedent, because they couldn't make a straight-faced defense of Roe as constitutional law. So the fact that President Obama comes out with a statement that's 180 degrees different from you know, people who are sort of rooted in constitutional law. You notice he's not making a constitutional claim here. Nope. You know, he's got some airy thing about freedom, but he's not going to explain it because nobody can explain it. Nobody who's had the opportunity to stand up in front of a court and try to defend it has tried to make that argument. On Mississippi, you know, I think that it's a monumental historic moment. So obviously the people who are attached to the case obviously need to get kudos for their performance here. But, you know, I think one interesting thing here, just reading through the Chief Justice's opinion, you know, I find this very ironic. I've always thought that he wanted to keep the court out of the hot button cases, and he generally speaking does. But what his opinion basically says is he thinks the majority goes too far. They reached out and basically decided this thing once and for all, where he says he wouldn't have gone any further than just upholding the Mississippi law. And I just, you know, looking at that, that would have just brought a continuing stream of abortion cases to the court, where, you know, they'd be in a position to saying, okay, this one's okay, just like Casey, you know, this is an undue burden, this is not an undue burden. But we would have all this ratcheted up emotion and controversy because there would just be case after case coming to the court. Whereas I think what the majority did here is simply decide correctly that this was never something the court was supposed to be in the first place. Right. And every second that it was in it, it was defeating democracy, which is where this is supposed to get resolved.
I made the point about an hour ago, but in these big cases, it takes a while for it to settle in. I often use the word marinade. You let it marinate, you think about it, you go away for the weekend, and you try and measure in your own way what the implications are. It's like the gun decision of yesterday. It's barely 24 hours old. We don't know ultimately what the implications of that ruling is for the 8 or 9 states that have very restrictive gun laws, including the one we live in New York. I think this is a similar case. Just take a moment and think about how it could impact American life or the state in which you live and the family you're raising. However, there are 3 liberal justices still on this court, and they are none too happy about this ruling today. Back to Shannon Bream, who's reading through a lot of the dissent opinion, Shannon, and what do you find in there?
Well, a couple of things. First of all, as we noted before, they all signed this together, all the dissenters. They all put their names on it, which is significant. We don't see that a lot. The last time I can think about that, not that it's the last time that happened, but the last high-profile example is I remember the original Obamacare case. Remember, there was some flipping of votes behind the scenes and the things that happened. Eventually, Justices Scalia, Kennedy, Thomas, and Alito wrote that fiery dissent, and they all signed their names to it. The same thing today. Sometimes these cases evoke extra emotion and passion about them. them. So today in the dissent, they talk about this. They think there's been damage to the court. They said, one of us once said that it is not often in the law that so few have so quickly changed so much. And they're actually quoting Justice Breyer, who obviously has signed on to this and will retire within a matter of days. They say, for all of us in our time on the court, that has never been more true than today. In overruling Roe and Casey, the court betrays, they say, its guiding principles. They write, with sorrow for this court, but more for the many millions of American women who have today lost a fundamental constitutional protection. We dissent. So they stick together in that. We've talked about the Chief Justice. We thought he was probably doing something like this after the leaked opinion, that he may be doing a concurrence. So what he's saying is, yes, I would have upheld the Mississippi law that bans most abortions after 15 weeks, but I don't think we need to go after Roe. He is well known for wanting to have as narrow a solution as possible. He writes this in his concurrence: both the court's opinion and the dissent display a relentless freedom from doubt on the legal issue that I cannot share. He says, I would have just decided the question we granted review for. The answer to that question is no. That law is not unconstitutional in Mississippi, but I see no need to go further to decide this case. So the split goes down as we would expect. But again, as you guys keep noting, I think it's important for people to know this sends this back to the states. I was riding on an airplane a few days ago, and a guy next to me said, I want to talk to you about this case. He had no idea that even if Roe and Casey were overturned, that this would now be a state issue. Some places more liberal, some more restrictive with this right. So it's, again, an important point to make for people as you say, Bill, this sort of ruminates, sinks in, and we figure out the nuance of what's been decided today.
We did a Fox poll, Shannon, first part of May, and we asked this question, Dana, specifically as it applies to the law in Mississippi, which is what was ruled on today. Do you support or do you favor or oppose abortion in your state after 15 weeks? And a majority, 54%, favor a ban after 15 weeks.
Right. And that's what the Mississippi law is. Jonathan Turley, maybe jump in here. I mean, this is not, in Mississippi, it's actually quite a lot longer than in many places around the world.
That's right. We're talking about that 15-week period. Sometimes that period is called the quickening period. This is a term that came from early in our republic and also in England, where the criminalization of abortion tended to follow what was called the quickening, or the first sensations of a pregnancy. Mississippi put their date right around that traditional period of the quickening. It turned out that that was not going to be the issue in the case, that ultimately you had 5 justices who believed that Roe and Casey were just built on what they believed to be bad law. It is, reading the Roberts concurrence, which I've done, is really a great example of what an incrementalist and institutionalist he is. It probably will be cited to really capture Roberts' view of what judging on this court is all about. He doesn't necessarily disagree that Roe and Casey were not constitutionally sound. He just frankly gets sticker shock. He believes that stare decisis means that you should be cautious and incremental. You shouldn't make these sudden turns on precedent. And so he says, I would just basically uphold the Mississippi law. I would cut back even further on the Roe-Casey line, but I wouldn't get rid of them entirely. A lot of people are going to read that and say, well, that's really divorced from principle. What comes out of both the majority and the dissent are very clear principles on how to interpret the Constitution. Is it there or is it not? Roberts is sort of unabashedly saying that's not the only consideration. I just think that we did more than we had to do.
Thank you. Congressman Mike Johnson of Louisiana, the Republican congressman, is joining us by phone. Congressman, let's get your reaction to this historic news today.
This is a big day. You know, 49 years it has taken to reverse this great tragedy. There is no right to abortion in the Constitution. There never was. It's not in its text or its structure or its meaning. And the court has finally said that decisively. Many of us have been working for this day our entire adult lives, and it is a great, joyous occasion. Listen, when the court invented the right to abortion, the federal right to abortion out of thin air, and said it was found in the penumbra of the Constitution, they imposed a tragically consequential social policy on America. And as a result, nearly or more than 63 million unborn American children have perished because of it. We've got to reverse that. We finally have, and we cannot overstate the importance of today.
Yeah, today, is this a surprise, however? Or really not so much, given the composition of the court, how it is today?
I don't think it's a surprise. We knew that we had originalists now, a majority of those who want to fairly and faithfully apply the Constitution as it's written, and this is the result of that. As we said, abortion obviously is not mentioned in the text of the Constitution, and it's nowhere in its original meaning. And so you have justices who are faithful to that interpretation, that application of the Constitution. That's what the Founding Fathers intended. That's what our nation has relied upon. And now this decision is returned to the political process, to the people, to be decided by the people through their duly elected representatives in most cases. And that's where it always belonged. And so it's been a legal fiction our entire lives, a tragically consequential legal fiction. And finally now, we get to make this decision where it has always been, it should have been made.
You mentioned the political aspect of that. That has begun already. Sir, thank you for your time. The House Speaker is already at the microphone on the Hill. This is just some 45 minutes into that ruling.
A nationwide abortion ban. They cannot be allowed to have a majority in the Congress to do that. But that's their goal. And if you read, and again, we're all studying all this, but if you read what is in the very clear, one of the justices had his own statement. It's about contraception, in vitro fertilization, family planning. That is all what will spring from their decision that they made today. It's such a contradiction. Yesterday, they say the states cannot make laws governing the constitutional right to bear arms. And today, they're saying the exact reverse, that the states can overturn a constitutional right for 50 years, a constitutional right for a woman having the right to choose. The hypocrisy is raging, but the harm is endless. What this means to women is such an insult. It's a slap in the face to women about using their own judgment to make their own decisions about their reproductive freedom. And again, it goes well. I always have said the termination of a pregnancy is just their opening act. It's just their front game. But behind it, and for years, I have seen in this Congress opposition to any family planning, domestic or global, when we have had those discussions and those debates and those votes on the floor of the House. This is deadly serious, but we are not going to let this pass. A woman's right to choose, reproductive freedom, is on the ballot in November. We cannot allow them to take charge so that they can institute their goal, which is to criminalize reproductive freedom, to criminalize it. Right now, they're saying in states that they can arrest doctors and all the rest. What is happening here? What is happening here? A woman's fundamental health decisions are her own to make in consultation with her doctor, her faith, her family, not some right-wing politicians that Donald Trump and Mitch McConnell packed the court with. While Republicans seek to punish and control women, Democrats will keep fighting ferociously to enshrine Roe v. Wade into the law of the land. This cruel ruling is outrageous and heart-wrenching, but make no mistake, again, it's all on the ballot in November. The Supreme Court has ended a constitutional right. This is 50 years proclaimed a constitutional right. What happened today was historic in many respects. Historic in that it had not recognized a constitutional right and then reversed it. This is a first. And again, just before, it imposed a constitutional right to allow for concealed weapons. How about those justices coming before the senators and saying that they respected, sorry to say, the precedent of the court, that they respected the right of privacy in the Constitution of the United States? Did you hear that? Were they not telling the truth then? Again, just getting to the gun issue, because really, in preparation for this morning, I was really in an exalted state about what happened in the United States Senate yesterday. Counterpoint to the dangerous decision of this Trumpian Supreme Court that they made yesterday, but a way to take us to, as the bill is called, community safety.
So this is just the first of a lot of reactions starting this hour, Dana, and you think about the gun ruling yesterday, the abortion ruling today, what is still out there, the EPA on climate change, Remain in Mexico deals directly with the border and immigration, religious liberty that directly deals with prayer at public schools. America, you could argue, is being transformed right now by this conservative court. 6-3 ruling on abortion.
On abortion. And then, you know, what Nancy Pelosi just said, that one of the things she said is that it will dramatically decrease abortions. That could be but a state like California.
Speaker of the House Nancy Pelosi reacting to the ruling, as you saw, passions running high outside of the Supreme Court because it was a bombshell decision, one of the most significant rulings in American history, which followed the first ever leak of a draft opinion. Today's decision, the same as back in May, overturning the landmark Roe v. Wade ruling, which made legal access to abortion the law of the land back in 1973. Now, this new ruling does not end abortion. It sends access to abortions back to the states, leaving them to decide to allow, restrict, or eliminate access. But it also raises a whole new slate of questions across the country, starting with those trigger law states, 13 of them. We shall see where it goes and how the White House and the president handles it. Meanwhile, stay tuned to this Fox station for more coverage of this historic ruling and more news. In Washington, I'm Griff Jenkins.
This has been a Fox News special report.
Jordan L. Jones from the latest celebrity gossip in her rumor report, and we're opening up the hater hotline. Let's get this thing started. Well, my ladies, ladies, do you feel me? With the family, solid every day. Oh, everybody say, got it. Appreciate you. With the family, yo, everybody say, that's what I'm talking about. Best energy.